All rise.
Lords, could I just pick up a couple of loose threads from this morning? The first was the question from my Lord Mance, which I didn't answer, which was in relation to paragraph 39 of our case, where you entirely understandably asked how claims before October 2000 could be couched in terms of Article 8 of the Convention. And the answer is that the wording of paragraph 39(1) of our case could have been rather more happily phrased. What we were trying to convey there is simply that having looked at the workload of the predecessor tribunals under the 1989 and 1994 Acts, the two principal categories of complaint were complaints about intrusion into privacy, which would thereafter be complaints by reference to Article 8, and complaints, as I say, about the failure to comply with authorisation regimes under which what would then have been IOCA rather than REPA. So 39(1) shouldn't in terms have referred to Article 8, but the sort of the thrust of it remains correct. The second point that I just wanted to revisit very briefly is that in the course of debate, it was put to me that section 65(2)(d) could not be used in order to assign to the IPT claims brought by any of the services, and I, on my feet, agreed with that. I think, on reflection, the services would prefer simply to reserve their position in relation to that. I perhaps agreed slightly too readily. I'm not going to try and persuade you.
Sorry, I missed the point. Actually.
Sorry, the point, it was put to, under 65(2)(d), the question was put to me whether I accepted that 65(2)(d) could not be used to assign to the IPT claims by the security services. On my feet, I did accept that. On reflection, the services would prefer simply to reserve their position. I'm not going to try and persuade you that...
it's extremely difficult to see how it would fit in to...
It would have to get into subsection 3. We would wish to reserve our right to argue that that could be done either through B or D. B, proceedings against any other person, that is, a person other than the intelligence services, in respect of any conduct or proposed conduct by or on behalf of any of those services. Conduct by another person might be publication in respect of any conduct by the services, an investigation by them. So, as I say, I'm not going to try and persuade you I am right. I'm just explaining why we would wish to reserve our position. And the same point could be made by reference to D, 3D. They are proceedings relating to the taking place in any challengeable circumstances of any conduct falling within subsection 5. So proceedings relating to a proposed publication concerning concerning surveillance activities would be conduct by or on behalf of the intelligence services, which takes place in challengeable circumstances, and an application to restrain publication could arguably at least be proceedings relating to the taking place of conduct. So,
the tribunal can give injunctive relief, can it?
Again, my Lord, that's not a point I would wish to give a definitive answer to now, but their jurisdiction is relatively broad, and again, it's not a point I would wish to concede that they can't. I'm not going to try and persuade you that they can. The third loose end I just wanted to pick up was apropos of our exchanges about the anomaly that arises from the services suing in the ordinary courts. As I understand, one of the ways that I think different people had slightly different views on what the anomaly is, but one of the points, if one takes, for example, the Shaler case as a real case, Mr. Shaler is sued in the ordinary courts. Let us assume he wants to run his Article 10 defence. It's said to be anomalous that he should have the opportunity to run it by way of defence in the ordinary courts, whereas exactly the same issues would be consigned to the IPT if he chose to counterclaim. One of the answers which I didn't give when that point was being run is that if one thinks about a real case such as Shaler, question whether it in fact would arise at all, because if one thinks through the logic of the decision of the House of Lords in Shaler, what was being said by the House of Lords is that the Official Secrets Act is Article 10 compliant because there is a whole array of alternative forms of disclosure, and an application could be made for authorised disclosure. For that reason, Section 1 of the Official Secrets Act, which makes it an offence to disclose, it doesn't strangle the right to freedom of expression because that freedom is protected by a number of other different routes. If one takes on board the logic of that ratio, and then one thinks about a civil action against somebody like Mr. Shaler, the situation is he has not applied for authorisation at all. He hasn't gone down the route of asking a senior officer within the service. He hasn't notified the Attorney General. He hasn't gone to one of the commissioners. He's simply made an unauthorised disclosure. A civil action is then brought against him for an injunction. Question is, well, could he at that stage say that the injunction is a violation of his Article 10 right? We would wish to argue no. That's not even an issue that's open to him in a civil injunction proceeding because he has overtly not pursued the alternative remedies which were available to him, which were identified by the House of Lords and which comforted them in finding the Official Secrets Act Article 10 compliant. So it may well be that in a real case, a Human Rights Act defence, or certainly in a case like that, a Human Rights Act defence actually wouldn't even arise.
The same would arise if it was a term of the contract, I suppose. Would it have been breached? You would simply point to the contract and say it had been breached.
Yes.
And if there was some issue about the contract itself, well, that could have been a counterclaim, but you would say, well, that would be caught
for the same reason.
By Section 65.
Yes. Yes.
And if it required to be litigated as a preliminary issue, then you stay the rest of the proceedings and go to the IPT for that issue to be determined.
Case handling ways of dealing with it, yes, exactly. Exactly. The only other discrepancy, the only other anomaly that I just wanted to deal with that has been put against us, and this wasn't, I think, explored orally, but it's in the printed case, it is said that the interpretation which we have espoused produces the result that former officers of the security services and intelligence services are treated differently from former officers within any of the special forces, for example. If a former SAS officer wants to publish he is refused permission, he gets to sue in the ordinary courts, and it said it's anomalous that we are producing a result under which former intelligence and security service officers have to go in the IPT. We have two short answers. One is just a bit of a riposte, which is simply to say that the anomaly, if it is an anomaly, is one that is not unique to our interpretation. It would arise equally on my learned friend's third interpretation, because his third interpretation is that the effect of 65(2)A is to exclude the jurisdiction of courts and tribunals in relation to challenges to investigative functions. But the more significant and more general and compelling response is simply to say that, yes, there is a difference of treatment. So be it. It is of necessity the case that the intelligence and security services are in a special position, and they are treated as a special category by other legislation, most notably Section 1 of the Official Secrets Act. Section 1 of the Official Secrets Act makes it an offence for an officer or former officer of the intelligence or security services to make a disclosure without the need to prove damage to the national interest. It was precisely that section of the OSA that was under challenge in Shaler. Disclosures by other Crown servants only involve criminal offences if damage to the national interest is shown. So simply to say, well, our interpretation puts former security service officers in a special position, so be it. They are in a special position, and they are rightly treated as being in a special position by other legislation. I mentioned the OSA. It is in the bundle of additional materials. Oddly, it didn't for some reason get into the authorities bundle, but there is, if you need it, there's a Respondent's additional documents. I don't ask you to go to it, I'm just telling you where it is. It's tab C in that bundle. You will also, if you do have it open, find in tab B, if you've been looking for the impugned decision in this case, oddly that didn't get into the appendix either. For some reason it wasn't agreed to, but you'll find that in tab B of that additional bundle at page 17.
Is it 17? Or was it 16?
Well, I'm just reminded, finally on the special position of the services, it was a point specifically made by Lord Bingham in the Shaler case at paragraph 36. Lords, that leaves the third and final subsection of this issue, which is convention issues. I've already anticipated some of that in the course of oral submission, and our printed case deals with it in some detail. So what I wanted to do was to make a number of, in a sense, general preliminary points, and then really leave it for the case to speak for itself. We make the following, I think I have seven general points that we would urge on your lordships in considering the convention issues that have been deployed in front of you. The first is simply this, that although in the case for the appellant, they do, in fact, if one looks at paragraphs 35 to 37 of their case, they do not suggest that the IPT is incapable of being Article 6 compliant. They accept the ruling, the IPT's own ruling on its own Article 6 compatibility, but they say it doesn't apply to them, because they say it's a decision that is only, well, they say it's a decision that is predicated on the need for NCND, that is, non-disclosure, effectively, of intelligence to outsiders. By contrast, the drift of Lord Panic's submissions appeared to be to go considerably further and to suggest that the IPT is, in fact, incapable of satisfying Article 6. Lords, so far as that is concerned, I would ask your lordships to bear this in mind, and it is not just a matter of form, it is a matter of real substance, that this case has got to this court without anybody, without the appellant, seeking a declaration of incompatibility in relation to anything in RIPA. If a declaration of incompatibility had been sought, a notice under Section 5 of the Human Rights Act would have had to be given to the Secretary of State. So I would ask your lordships to proceed on the basis that RIPA, the primary legislation, is convention compliant. And one then works that forward into the question as to what is really in issue here. Now, we quite understand from Lord Panic and also from the appellant that they don't like all of the IPT rules. But if, as this particular case or any other case plays out in the IPT, if it emerges that there is some respect in which the IPT rules themselves fail to satisfy Article 6, then that is a question that the IPT itself can address, as it did in its own ruling on Article 6, and if it found that some provision in the rules was incapable of satisfying Article 6, it could either read it down on the particular circumstances of the case or treat it as ultra vires, as it did in its own ruling on Article 6. And if it did that, it would be free under Section 68(1) of RIPA to devise its own procedure. And simply as a footnote to that point, if I could just mention one thing which my learned friend was wrong about in relation to the IPT's ruling on Article 6. He addressed you as if, now that it's been decided by the IPT, it is carved in stone and incapable of review. In fact, the IPT itself said, in paragraph 14 of that ruling, the rulings do not constitute a precedent binding on the tribunal. So they do not regard themselves as being bound by their own previous rulings. So if, in a particular case, a litigant comes in front of them and says, well, look, I hear what you said in your Article 6 ruling, but either you're wrong as a matter of principle or you're wrong on the facts of my case, he can ask the IPT to revisit it. And so it would be wrong to regard that ruling as essentially a sort of a blanket and indefinite ruling on Article 6 compatibility hereafter.
How do they put that in?
I'm sorry, it's paragraph...
Just remind us whether...
Sorry, it's Authorities Volume 5, tab 40, and that passage I mentioned was paragraph 14, which is page 7, and it's 4 lines from the end of page 7. The rulings do not constitute precedent binding on the tribunal. Or in any other court or tribunal, they add.
Oh, yeah. Light of experience.
Yeah, absolutely. So, Lords, if problems, as I say, problems arise as cases work their way through the IPT, then that is the solution. Alternatively, if it is found that an incompatibility in the rules necessarily arises because of some provision in primary legislation, and the legislation itself can't be read down, well then, in that particular case, somebody may wish to bring a complaint seeking a declaration of incompatibility in relation to primary legislation. But as I say, the starting point in this case is that that's not the position. We're starting from a position in which no declaration of incompatibility is being sought in relation to the primary legislation. So if, as the case plays out, a convention compliance problem arises, our submission is that the way to fix it is by doing what happened in the IPT's ruling on Article 6, that is, to tweak the procedure of the IPT, not to do what the appellant is trying to do, which is to use the possibility of a convention incompatibility in the future as a tool for producing a strained interpretation of the IPT's jurisdiction.
Would the rules be attacked in judicial review proceedings?
Could judicial review proceedings be brought against the Secretary of State for having himself? As a matter of principle, I can't see why not. The second preliminary point, so in a sense, that is, in a sense, our sort of global answer.
But in a freestanding action, do you mean?
Subject to the usual public law principles of sufficient interest and delay and everything else, yes. I mean, in principle, it is subordinate legislation which has been made by the Secretary of State, and it would be amenable to judicial review.
By a victim?
By a victim.
As I say, why wouldn't that be? Would that be consistent on your case with section 65 and or section 69 subsection 8, 67 subsection 8?
Yes, because it wouldn't be impugning any decision of the it wouldn't be seeking to bring a convention complaint against the services other than in the IPT. It would be a convention complaint against the Secretary of State.
And it wouldn't be impugning a decision, and that submission or that conclusion is reinforced by the passage you just pointed out, which says that this isn't a decision between anyone except the parties.
Exactly.
Yeah.
And that, in a sense, is our global answer to the whole attempt to use the convention as a sort of a crowbar into a kind of roving examination of the compatibility of the IPT rules with the ECHR. In our submission, it's simply not an appropriate process where what is being discussed is simply the jurisdictional provision in 65(2)(a). Second preliminary point is that insofar as you do look at the convention complaints, we would again, I foreshadowed this, but we would again urge on your lordships that it is wrong to regard the IPT's procedures as some inflexible regime carved in stone, incapable of adaptation to different circumstances. It is capable of adaptation, and it does adapt, as we have seen. It is not right to say that no disclosure is given. Disclosure can be given pursuant to Rule 6.3 of the IPT rules, and we discussed before the short adjournment that if one of the security intelligence services refused to give its consent under Rule 6.3 to disclosure, that refusal itself could in principle be challenged in the IPT as thwarting the convention rights of the complainant to a fair trial under Article 6. Secondly, as we know, oral hearings, inter partes oral hearings can be heard, and they are held. We have an illustration, several illustrations in the authorities bundle. The Frank Steiner case is one of them. I don't ask you to go to it just for this, but it's bundle 2, tab 12, and it recites at paragraph 5 the fact of the inter partes oral hearing that was conducted. Third point under this heading, following the ruling on Article 6, inter partes hearings can be held in public. Or, if they're held in private and it subsequently emerges that they didn't need to be held in private, what the IPT can do is to do what it did in its ruling on Article 6, which is to hear the case in private and then publish a transcript of the argument as well as publishing its judgment. That's paragraph 13 of the ruling on Article 6. Fourthly, again, as we know from that case, it's not just its hearings, but its rulings can be published. And as I say, we've got 3 illustrations of that in the bundle: C and the police we've looked at, the Article 6 ruling, and the Frank Steiner case.
What's the authority for publishing a ruling if it's against someone? Can that be done?
Under the rules as they currently stand, the answer is no. But if one is looking at the primary legislation, as I mentioned just before the adjournment, Section 68(4) actually effectively allows rules to be made that would permit a losing party.
How does that come about? Is that
It's
subject to any
because
rules?
subject to any rules made by virtue of 69(2)(i),
Yeah.
a ruling shall be confined to A and B, and rules can be made under 69(2)(i), requiring information about it and determination to be provided. We've already seen, just going back to my little list of flexibility, we've seen that the IPT doesn't consider itself bound by its own previous rulings. We also have seen from the IPT's decision in C against the police that it can and does appoint advocates to the tribunal where it feels it would be assisted by that. One just sees that from the list of representations in C and the police. That's bundle 1, tab 6. We see no reason, my lord, in principle, why, if something more than an advocate to the tribunal is needed, why a special advocate shouldn't be appointed to assist the tribunal. And as I also mentioned, without, I think, taking you to the provision, the tribunal has an express power under section 68(2) in connection with the investigation of any matter or otherwise for the purposes of the tribunal's consideration or determination of any matter to require a relevant commissioner appearing to the tribunal to have functions in relation to the matter in question, to provide the tribunal with all such assistance, including the Commission's opinion as to any issues falling to be determined by the tribunal as the tribunal think fit. So the tribunal can be assisted not only by advocates but by perhaps the best informed public authority by means of requiring not just information but opinions. So that's the second general point we wanted to make. The whole line of submissions advanced, particularly by Lord Panic, appeared to progress on the assumed basis that the rules were simply immutable and inflexible, and for that accumulation of reasons we say that is wrong. The third preliminary general point in relation to the Convention is obviously that the immediate issue in this case is simply whether this claimant can bring his claim by way of judicial review in the ordinary courts. If we are right, as we say we are, on the interpretation of section 65(2), the answer to that is no, unless you are driven to a different answer by the demands of the Convention. But it is trite Convention law that the question of whether or not there is compliance with a particular litigant's Convention rights is context specific. In this particular case, you do not know, this is not a criticism of anybody, but it is simply a statement of fact that you don't know anything about the facts of this particular case. All you know is the occupation of the claimant and the job description of the defendant. You do not know what issues are going to be at stake. You've been told in general terms that the claimant's been told a lot as to why we object to disclosure, but you don't know, really with respect, anything of any detail about the nature of the dispute that is going to be conducted. And so in our submission, it is impossible to say in prospect now that a hearing in the IPT of this case is incapable of satisfying this claimant's Convention rights. The fourth preliminary point we just wanted to make is that, and it's a very closely related point, that insofar as one is assessing the demands of Article 6, and secondly, whether those demands are satisfied in any given case, the court should bear in mind the truism that the demands of Article 6 are not constant in all cases, and it is well recognised that national security is a legitimate objective which may justify restrictions being imposed on a litigant's right to access to information or on the adversarial process that one would normally hope to find. Lords, could I deal, just in the interest of time, with my authorities relatively lightly by giving you some short citations rather than asking you to pull out and read now all the passages. The best authority, it's repeated in endless cases, but perhaps the best authority, simply for identifying national security, as a legitimate objective which can justify restrictions being imposed on the normal adversarial process is the case of Tinelli and McElduff, which is Authorities Bundle 9, tab 84, paragraph 72 to 78. Next point under this same heading on the textured nature of the demands of Article 6, the functions of the intelligence and security services themselves in protecting national security are themselves a fundamental element in the state's obligations under the ECHR. They are not in apposition to, they are absolutely an essential part of the state's own obligation to protect life, limb, property, and more fundamentally, in a sense, political democracy, because, of course, the preamble to the European Convention on Human Rights recites that the high contracting parties consider that the maintenance of political democracy is the best safeguard of the rights that are guaranteed. And this was a specific point that was touched on by the IPT itself in its ruling on Article 6 in paragraph 59. And I do urge paragraph 59 of the IPT's ruling on you, because it does, in our submission, put the whole question of national security in its proper place as a pillar of the ECHR, not as some sort of obstacle to it. The next point under this heading, my lords, is that in relation to the activities of the intelligence and security services, it may be blindingly obvious, but it's comforting to see it being said, secrecy is going to be necessary and is likely to be proportionate. We would cite Class and Germany, Bundle 8, tab 71, paragraphs 57 to 59. And two final points under this heading. The first is that the margin of appreciation in relation to protecting national security is wide. Again, a point often made, but perhaps most succinctly in Esbester, Bundle 7, tab 60, page 74. And finally, not only is the margin of appreciation in relation to national security wide, it is wider in relation to civil than in relation to criminal proceedings. And these obviously are civil. And that is Dombo Bahir, Bundle 7, tab 58, paragraph 32. The fifth general point, by way of introduction, is that Strasbourg has had occasion to consider and reject complaints about the procedures of the predecessor tribunals to the IPT, the Security Service Tribunal and the Interception of Communications Tribunal, along the lines of some of the complaints made here, most particularly the objection that they couldn't give open judgments. And those complaints were consistently rejected with perhaps excessive enthusiasm. We've included 5 such cases in the authorities bundle. I'd only perhaps urge you to look at 2 because they become repetitive.
Could you give the proposition again? I'm so sorry. I'm trying to trace as you go along.
Strasbourg has had occasion to consider and reject complaints about the procedures of the predecessor tribunals, predecessors to the IPT, namely the Security Service Tribunal under the 89 Security Service Act and the Interception of Communications Tribunal under the 1994 Act. The most helpful cases, I think, are Esbester, which I mentioned a moment ago, Bundle 7, tab 60, at page 75, the complaint there being that the tribunal couldn't give open judgments, and the complaint was rejected. And Christie, which is Bundle 6, tab 53, which was essentially a comparable complaint against the Interception of Communications Tribunal. There are three other cases mentioned in our printed case. The Patricia Hewitt and Harriet Harman case is there, Preston and Redgrave, but they all once, Esbester and Christie, had set the tone. Those cases simply show that these were not aberrations. This was a consistent line of Strasbourg jurisprudence. What might be said against us is that those were all cases that were argued and decided by reference to Article 6, by reference to Article 8, rather than by Article 6 or Article 10. But given the approach of the Strasbourg organs to justifying restrictions on the right to a fully adversarial process under Article 6, which we've seen through Class and Tinelli and so on, in our submission there is absolutely no reason to expect that a different result could follow by couching the complaint by reference to Article 6 or by Article 10 rather than Article 8. And I would mention on that point that the IPT ruling on Article 6 itself, at paragraph 113, seems to have accepted this point. They seem to have accepted that the procedural guarantees under Article 6 would have to be the same as the procedural guarantees of a fair trial under Article 6. And so where we get with that point then, Lord, my fifth preliminary point, Strasbourg having looked at predecessor tribunals, we would invite this court not to go further than Strasbourg has so far done. My Lord Brown asked when my learned friend was opening, is there any Article 10 case that helps? The answer is there isn't anything that deals directly with Article 10 in the kind of national security context we're looking at. The Moldovan case my learned friend cited really was nothing to the point. My Lord Panic drew your attention to spycatcher in the ECHR, but again, all that tells you is that the fact that a state says publication is contrary to the public interest doesn't prevent some form of judicial scrutiny. It doesn't assist you in answering the question that my learned friends are trying to deploy in front of you. Sixth point, just in a sense a footnote point, although the IPT itself, in its ruling on Article 6, as you've been told, has held that Article 6 applies to its hearing, and although the respondent in this appeal is not arguing that Article 6 would be inapplicable in this case, you should, because you are in a sense being asked to conduct a sort of a roving review of the IPT generally, you should be aware that Article 6 will not necessarily apply in all cases that come before the IPT, and we mention in our case at paragraph 90
Bulgarian case.
Yeah, exactly, which actually follows Class and Germany on the same point. Class at paragraph 58. So articles do not assume that
Bulgaria is reported. Where is it in our bundles?
it's not. We didn't include it simply because it's not. I may be corrected, but I thought it wasn't. I wasn't going to take you to it because I'm not arguing that Article 6 is inapplicable. I just wanted to put the marker out for you not to assume that Article 6 will always be applicable in relation to complaints before the IPT.
Well, I would certainly like to see it.
What I can point you at is Class and Germany, paragraph 58, which is Bundle 8, tab 71, which is another illustration of the same point.
What, Article 6 doesn't apply?
In relation to that complaint. I'm not saying it's this vexed question that Strasbourg has to grapple with as to what is a civil right, and if it sort of falls within the sort of continental concept of a public law right rather than a private law right, then it may fall outside Article 6. It's that area of the law. But more as I say, I didn't want to explore it because it's not a point I'm arguing in front of you, but I just wanted you to be aware that it is a point out there.
Which paragraph of Class?
Class, paragraph 58. Oh, I'm terribly sorry. Yes, no, sorry, it's just the way case names are given. Sorry, the Bulgarian case is in bundle 12, tab 118. I'm sorry, mine's not marked up, so I can't immediately take you to the relevant passages, but it looks like it'll be... One oh 4, 5, 6. Yeah, no, it follows class 106. The first issue to be decided is the applicability of Article 6. The Court notes that it did not express an opinion on the matter in its judgment in the case of class where a similar complaint was made. However, the former Commission did rule on it in its report in the same case. It found not applicable. The Court doesn't perceive anything in the circumstances of the present case that can alter that conclusion.
Paragraph 58 of class, that's not about whether these are civil rights and obligations, is it?
Sorry. No, you're right. I'm sorry. I've got a wrong reference there. But the Bulgarian case is the one we mentioned in our printer case. I'm sorry about that. The Bulgarian case is the one that does rule on
And
it.
what paragraph is it in the...
The Bulgarian case is 106.
It refers to class paragraph 75.
Yes.
That's the one we should be looking at.
Hang on. No, I'm sorry, I don't know what's happening.
Actually,
My
57
fault.
to 61
Yeah,
in the better.
Then, yeah.
75 in class is where it's dealt with, as the Bulgarian case says, yes. Final point, my lords, on the final preliminary points in relation to the convention arguments is that my learned friend Mr. Miller made a number of submissions in relation to Article 10 specifically, saying that it required a reasoned judgment. For the reasons I've developed in the last sort of 15 to 20 minutes or so, we would submit that it would be anomalous and indeed wrong to suggest that Article 6 would require anything different from Article 10 should require anything different from Article 6 in this regard. But secondly, it's not a complaint that appears to be available to this particular appellant, because the one thing that he tries to take the point to his own advantage, but one of the peculiarities of this case is that he already knows in considerable detail the grounds upon which the Security Service object to disclosure, and that is evidenced by the decision letter, which I mentioned, which is in our additional authorities bundle. So this is not a case in which there is any real force in the complaint that the claimant doesn't know the case against him. If the case is found against him, and that is all he is told, he will know in substance that the tribunal has accepted the case put to them by the Security Service, of which he is already substantially aware. So where we get to, essentially in relation to the convention, is that we say, so we would submit to your lordships that it's unnecessary and undesirable to embark on a sort of an abstract, generalised investigation of the compatibility of IPT procedures with the convention. Particularly since it wasn't really the approach taken in the courts below, and it's something on which you don't have the benefit of any judgments in the courts below. The question before you is essentially a narrow one. It is a question of interpretation. In our submission, there is nothing, either in the various anomalies that have been postulated or in the convention arguments, to suggest that you should be driven to any different conclusion. Lords,
Can I just be clear? I mean, in the case in Strasbourg challenging the IPT decision,
I mean, is this being dealt with entirely in, in the abstract? I mean, without reference to facts of individual cases? How are they going to deal with it?
I don't know. I haven't seen all the papers in that, my Lord. So I don't know exactly how that is argued out. But I mean, Strasbourg has in the past found itself in the position of having to deal with things on an assumed basis. You'll remember that there were some of the earliest cases on interception were brought where somebody was complaining that they were having their post or their telephone communications intercepted, and that this was unfair, and the state answered with neither confirm nor deny. So Strasbourg simply didn't actually know what was happening on the facts, but that didn't stop it. Ruling on the compatibility of the legislative regime. And sometimes the state would help by simply saying, well, we're not going to tell you what happened, but for the sake of having a ruling on this point of law, we will argue the case on the assumed basis that there is interception, or at least...
That's entirely different. I mean, in the old days, with Malone, for example, with interception, I mean, okay, you assume there's interception, and you ask whether actually under the informal Secretary of State's guidelines then in force, that was in accordance with law, held not. I mean, there isn't a problem with that, but I don't see how you decide. I have difficulty in understanding how you decide these sort of general Article 6 questions in the abstract.
Well, Lord, as I say, I'm sorry, I'm not involved in that case, and I haven't seen how it's pleaded against the UK, or I have seen our responses.
I mean, that would be the trouble, wouldn't it, with a freestanding proceedings against the Secretary of State in a vacuum as to whether or not the rules were or weren't Article 6 compliant, because without some kind of factual basis for the argument, your side, anybody who had a go at that would be met by your side saying, well, this is the Secretary of State saying this is perfectly ridiculous, we can't decide this in a vacuum. You've got to know what the...
Difficulty is they appear to have done just that.
Sorry, Lord.
They appear to have done just that in their ruling.
The
And they
IPT,
decided in the abstract.
Yes.
And they found it very difficult.
Yes, they did. But this case, cases can and do produce actual facts. See in the police as an illustration of a case where, in fact, there weren't any disputed facts, or indeed any need...
But you were suggesting a little earlier, where have I misunderstood this, that these questions of incompatibility and the like could be tested in a separate freestanding High Court proceeding, which wouldn't be affected by the statute, notwithstanding the fact that it would be done on a purely hypothetical basis.
I entirely accept that as a matter of principle, the Secretary of State can be judicially reviewed for having made the IPT rules. Yes.
And in such a proceeding, issues of incompatibility could arise too, could they?
Exactly. I mean, how the court would decide them, it's a matter of speculation. But
I'm a bit concerned that what will happen is, of course, it's forensically valuable for your side to make that point now, but at these postulated further proceedings in the High Court, you can just imagine what would be said on behalf of the Secretary of State. And this is just an exam paper. The court's not here to decide exam questions. They're here to decide issues between parties.
Yes, well, if a party didn't satisfy the judicial review threshold of having a sufficient interest in the issue, then yes, that would be the answer. If he was a victim, if he had a sufficient interest, then presumably he would have a sufficient interest by reference to some facts known to him. Otherwise, he'd be a busybody.
Well, you have to be a victim to get to Strasbourg anyway, don't you? You have to have something before them to say you've got a case to be dealt with.
Adverse ruling without any reasons.
You're going to get the answer from Strasbourg or something.
Yeah.
But in it.
Sorry, how did that?
On an abstract basis.
Yes.
Good.
I suspect they'll just uphold the idea.
No. Is the fact Kennedy is this case? Is that public knowledge?
That's best a line of cases. Yes, you can. Seen in that in this context. That's what we do all the time.
Sorry, can I just take instructions on one factual point? but I wanted to make a factual point that I thought might help, but I don't think it's in the public domain, so I can't. Lords, having made those lengthy introductory points, the detail of what we say in response to the complaint of convention non-compatibility is set out at length in paragraphs 111 onwards of our printed case. Other than taking you to the various passages in the authorities and reading them with emphasis and enthusiasm, there's actually nothing we have to add to what is said in our printed case, and I didn't want to lengthen my submissions by going through it. It's paragraphs 111 really through to the end of the printed case. It stands, it speaks for itself, I hope, and Lords, there's nothing we wanted to add orally to those various points. They provide the counterblast with the assertions made on behalf of justice, for example, in relation to all the various points that raise the inability to have a public hearing, witnesses, cross-examination and judgment and so on. But Lord, there's nothing I think that we need to add to that orally. So unless I'm going to be prompted with anything further, those are the submissions on behalf of the respondent.
Just help me with Mr. Miller's point on section 65(3)(c) and D, which, as he pointed out, are capable of fighting without any reference to the intelligence services, are they not? Can't they deal with the police and people like that?
I'm sorry, Lord, I was just...
Section 65(3) C and D,
Yes.
they can relate to police with no involvement from any of the intelligence services.
It is entirely possible that that is the case, but if they are proceedings that involve a challenge brought to any of the activities which are regulated conduct under RIPA, then they are going to be challenges that relate to exactly the deployment of techniques and operations which are going to be common to investigative authorities. So whether it happens to be the police deploying that technique rather than the security service, or quite possibly the two in collaboration with each other, it doesn't make any real difference as to the identity of the public authority that's being impugned. What matters, as I say, is the nature of the evidence that would be relevant and the nature of the scrutiny to which the conduct would be subject.
That applies if the relevant body is the Commissioners of Customs and Excise as well, does it? Because they're listed in 55(1), which one has to read with 55(4), which reads itself into section 65.
Yes, absolutely.
3C.
Absolutely it does, yes.
So it would be the investigatory powers of the customs. That would be the subject of inquiry.
Yes. I mean, one gets into sorry. Yes. Yeah, but one gets into subsection 6 through. You only get into subsection 6 through subsection 5, and you only get into subsection 5 through subsection 3D, which are challengeable circumstances.
I mean, the only point to be borne in mind is that actually the ambit of the Act and the rules and the restrictive, you would say justifiably restrictive regime of adjudication it involves actually extends beyond the intelligence services to a wideish range of other bodies.
It deals with the intelligence services as bodies, and it deals with the investigative powers of other bodies as well. That's how it works, yes. Yes, it's been pointed out, actually, sorry, that The case of Kennedy is in fact in Strasbourg the case that went through the IPT as the ruling on Article 6. And so one sees what actually happens in Strasbourg is that they do have a real case that has been worked through the IPT, and one sees from the IPT's own ruling what the nature of the complaint is from the IPT's ruling, paragraph 17.
Page 9.
Exactly.
Yes.
So what that is, and since that ruling is a public ruling, then there's real material for the Strasbourg court to engage with. So I don't know that's a complete answer, but at least it's a sort of some assistance in reassuring your lordships that what Strasbourg is dealing with is not some entirely abstract, factualist dispute.
Just as a matter of interest on the width of this, Section 55.4 carries you back to Section 49, dealing with the giving of notice when you've seized or got possession of information and you need the key to it, you can give notice to someone who has the key. Section 49 talks of any person who's come into possession of information by means of the exercise of any statutory power to seize, detain, inspect, search, or otherwise to interfere with documents or other property. Am I not right that, in fact, a very large number of people have such statutory powers, including local authorities in some circumstances?
Lord, I'd have to take instructions. I don't have a ready answer to that. We can provide one in writing if it would assist you.
I think it is just of some interest to see the potential width of the claims which might end up on your construction going in front of the IPT. It may not be more than that.
Yeah, I'm glad.
Thank you. Mr. Capel? Mr. Miller?
Right at the outset of the Learned Friends submission, the issue arose again about performance substance, if I can put it that way. The fact that our case gets trapped that way by 65 to A on the footing that in form and in form it's section 7.1a claim. And of course the Learned Friend says in substance that's what it is. It would have been open to thinking about this because of Lord Brown's questioning about what his position had been before the Human Rights Act, or even if you just eschew the possibility of framing your claim in case of the 7.1a case. One possibility we could have received in this case would be to bring our case in the Chancery Division for a declaration, tackling the application of the confidentiality obligation, the civil obligation that applies to my client, and the OSA obligation. And what one would say is, look, at common law, the strictness of that confidentiality obligation may be mitigated by, for example, the assertion of publication is in the public interest, or reveals wrongdoing, no confidence in iniquity, and all that sort of stuff. But in the Human Rights Act era, the Chancery Division is, of course, bound by Section 6 of the Human Rights Act not to act incompatibly in the end result of the case with our Article 10 right. And so you then get to the argument, well, the Section 10 methodology that we see in Shaler has to be factored into our domestic law of confidence, just as the Article 8 methodology, Section 10, Article 10 methodology has to be factored into our law of confidence as a further consideration, just as in the Naval Campbell case, for example, Article 8 gets factored into the common law of confidence to extend it to a privacy claim and indeed to a contest between by virtue of Section 6 of the HRA in the Chancery Division an application for resurrection and ask the judge to do exactly the same thing that is envisaged to be taken, just not in the administrative court, and not framing our case as the Human Rights Act, framing it as a challenge to the ruling under the decision on the confidentiality obligation of the services.
Would you make any mention of the Human Rights Act at all if you were putting that argument forward?
You certainly make a mention of Section 6 and the obligation to respect Article 10 principles in determining the confidentiality issue.
Wouldn't you think it necessary to help the judge a little as to what those were?
Yes, you would.
Surely it would.
But then,
Yeah. You're really taking the Article 10 points. You're saying, look here, you've got to look at Article 10, the requirements of that, look at the strategy, and therefore you've got to, whatever it is, give this duty of confidence that much less weight and all the rest.
but on the loan friends case, we can't do that. We can't go to the Chancery Division in that way.
No, quite.
We have to go to the IPT.
Absolutely.
And there is an anomaly there, because in essence what you're doing there is exactly the same as if the state can move for an injunction against us. We'd be raising exactly the same Article 10 methodology in our defence in the Chancery Division.
But they say that, given that part of the content of your claim would be a significant reference to Article 10 and all the jurisprudence, they say that that is, you are in essence, quote, bringing proceedings against the authority under the Act.
Yes, but
and if one looks at it in a broadish way, you are. Because it would be almost impossible, as my lord has just pointed out, to plead your case solely at common law without reference. You might be able to avoid putting any reference in your pleading, possibly, if you were particularly sharp. But it would be very difficult to see how you could have the debate at the trial without the balance required by Article 10.
No, I agree, but because the width of Section 6, Section 6 is very wide, it applies to any public authority, it applies to any court. So the potential is for pretty well any claim against the intelligence services which you bring in a court, where you raise some sort of argument that the common law should maybe, the result of the common law claim, or whatever the claim is, should be this in order to avoid incompatibility with a particular convention right. For example, Protocol Article 1, if you're complaining about the security services interfering with your property, taking the property away without justification, you'd always end up being forced into the IPT with that sort of claim. And all we're saying is, it seems to us, we're getting an awful long way there from what on a straightforward reading you think is being forced into the IPT, which is some claims involving the use of regulatory powers, essentially Article 8 claims, where the extra powers of the state to intrude into your privacy are being abused. And one could endlessly think about examples of common law claims or other claims that you might bring against the intelligence services, where some citation of human rights jurisprudence might arise. In what in form is not a box ticked in the hat, but it's a straightforward common law claim.
But as long as your claim is one which is made against a public authority and is dependent upon a convention right, you are within Section 7.1a. If the position would be that as against another private authority, the convention right, the convention right wouldn't apply there, and if the common law, you would fail at common law, if it were not a public authority but a private person you were suing, that proves the point that in fact you're suing or claiming under the Human Rights Act, doesn't it? I mean, if the truth is how, in contrast, that the common law has developed because the court has developed it both for private defendants and for in cases where a public authority is a defendant, that may be a different situation, and I think that's what you were hinting was that might be the case.
No, I do understand that, but the problem, what we're ultimately asking on our case in all these situations is why on earth
The point about jurisdiction is quite capable of arising in cases which have nothing to do with the IPT, because Section 7(1)(a) of the Human Rights Act is subject to a one-year time limit, and it seems to me there will often be, or could often be, these anomalies that you're suggesting, quite independent of intelligence service claims. In some circumstances, someone may be bringing proceedings which are subject to the time bar, but if he were sued for an injunction after the year had elapsed, he could still rely on the convention. That may be said to be an anomaly, but it is what the Human Rights Act provides.
Yes, no, we do understand all that, but ultimately the issue is one, on the first point, on the second meaning, it's one of construction. Do you go for the wider meaning of tribunal, or the narrow meaning of tribunal, the literal meaning? And the consistent theme in our case is that you have to bear in mind the question, does the premises construction have adverse consequences for my client in terms of his normal right of access to a court to assert his rights? It's a standard common law principle of construction. If there are two available constructions, the court should lean against the one which has an adverse consequence for the citizen in terms of accessing the court with full trial rights to assert his civil rights. That's a novel argument. It seems to us there is a very large package of adverse consequences for persons such as my client and other litigants wanting to raise Human Rights Act points, if you give it the narrative, you give it the wide construction. You say that all of these sorts of cases, if any Human Rights Act point is raised, have to be forced into the proceeding with the IPT.
Well, that's where the language of 65(2)(a), as was pointed out, is rather against you, isn't it? Because it does use the expression in relation to any proceedings under subsection 1a of section 7. It could have restricted it, but all convention rights and all claims that fall within 1a are brought in.
Yeah, so it's better, as I think the law pointed out to my friend, if you read the any as more referring to the last bit of section 65(2)(a), any case falling within having both characteristics,
yes,
section 7(1)(k) and full case and falling with subsection 3, it has a rather different emphasis and a rather different meaning.
Okay, so, but I mean, the door is open by the earlier part of the phrase to any proceedings that have that characteristic, and it means that all breaches of convention rights affecting the intelligence services are brought in.
But with respect, one couldn't say that even looking at the words only in any, you couldn't read section 65(2)(a) the way we're reading it. The reference to tribunal is to a tribunal of specialist jurisdiction rather than the court of general jurisdiction. You couldn't say you couldn't read it like that. So in that sense, looked at linguistically, it's ambiguous. And that's why we're entitled to say we should avoid the adverse construction. It's disadvantageous to our access to the normal courts. As far as the position for the HRA is concerned, Lord Brown raised this. We haven't got ex parte Smith, which was the case about homosexual members of the military, if you remember. But I think the position before the HRA was anxious scrutiny if you raised the human right argument in the admin court. And the scrutiny would be more or less intense, depending on the gravity of the human rights violation alleged and the issue.
Yeah, but it wouldn't be enough for Strasbourg purposes.
No.
That's why we breached Article 13 in Smith.
I agree with that, and I haven't sort of persuaded us to say before and afterwards, but of course we get to the iconic result on this case, that we're actually worse off afterwards in procedural terms, but by virtue of the fact that we've got the Human Rights Act Section 7(1)(a) claim, which gives the court the full power to review the facts, because we can't do it in a court. We get the benefit of the change in the way in which the court scrutinises the Article 10 point, but we're dragged away from the court to the IPT, which seems to have, with respect to very odd results.
The difficulty is you're just focusing on one thing, as if access to the court is the sole and ultimate good. As has been pointed out, there are some compensating factors. The tribunal sees documents which wouldn't otherwise be seen, and hears evidence which wouldn't otherwise be heard.
Well, yes, no, I mean, that may or may not be true. That may be true in certain cases, but the fact is that from our client's perspective, it is an adverse, he is saying it's an adverse consequence, and it's an adverse consequence for reasons I'm going to go through relating to this case.
What if it's a balance? I mean, there are some people who think it's preferable to sue in the tribunal. That's why in C against the police, Mr. C preferred the tribunal, and the public authority was arguing the opposite.
Yeah, but in our case, there's no problem with that, because you can do that. If you feel
You get the choice, you get the option.
Yes, but subject to the courts, the High Court saying we find jurisdiction because it should be over the IPT, and the County Court saying, well, frankly, it's abuse to try and start here. You know, that is a fanciful possibility, one would have thought, after any ruling in this case. If anybody wanted to try and start a case against the intelligence services in the court, they'd go to the admin court, wouldn't they? They'd be crazy to try.
Well, they might find Lord Justice Mummery and Mr. Justice Burton sitting as a divisional court.
They might do.
At least Mr. Justice Mummery and Mr. Justice Burton would, Lord Justice Mummery and Mr. Justice Burton would have all the powers of the High Court doing that.
Yeah, exactly. Plus their specialist knowledge, so there'd be a we were also pondering. What happened in the spy capture case. Just for the record, I think what happened in the spy capture case was that newspapers ended up being injuncted because they wanted to publish extracts of the book. They asserted it wasn't Peter Wright who was the leading comes to court case, so it was Wright's publisher, it was the newspapers who were doing it. But they did assert free speech rights in support of their right to publish the extracts, saying that it was in the public interest, and so on and so forth. And they referred to Article 10 in support of the argument on the injunction, and ultimately took the case to Strasbourg on that basis. But the case got overtaken by the fact that it had been published in America and brought into this country by that stage. But I mean, these arguments about freedom of speech have always been in play in these sorts of cases, to answer Lord Brown's point, certainly as far as one's recollection of spy capture is concerned. And that is precisely because if you're not properly being restricted in Freedom Rights Act, you're not properly being restricted under the obligation of confidence. You know, if there are good public interest reasons to publish or you're exposing iniquity, then there is a common right to publish. It's your freedom to communicate the information well known to the public. And of course, that's the difference between the common law position in relation to Article 10 and privacy, which is what we was principally dealing with. There wasn't a common law right to privacy before the HRA. And the big change as far as the area of activity that WEPA is looking at and the tribunal is looking at is that you can now rely directly on Article 8 in domestic claims.
But do you, whatever the position was before the Human Rights Act came in, do you concede that these proceedings are proceedings under this Act within 7.1a? Do you concede that? You do concede that?
Well, we can't dispute it because the whole case is on that basis. It's the first instance case.
So whatever might have happened...
And Malone French is quite right. I'm sorry, sir.
No, I was going to say, whatever might have happened in some other case or in some previous incarnation in this case, you concede that these proceedings are within Section 7.1a.
Yes, yes. This is just an odd outcome of the absurdity point when you're looking at the construction issue. But on our case, if the application for the declaration wasn't a Section 7.1a claim in the Chancery Division, but just a straightforward confidence challenge, then what is the difference? I mean, it couldn't be more than obvious that we've just made the mistake of going in the admin court, in the public law claim, ticking the box and conceding that it was Section 7.1a.
But since we've now got the Human Rights Act, it's almost impossible to carve out a common law claim anymore. Yeah. As you pointed out, it's the duty of the judge to apply the Human Rights Act. So the judge said to himself, well, the Human Rights Act claim will be time barred, so I've got to put myself forget about human rights now, but apply very similar principles on a common law basis. Be bizarre and not practical.
But it does present difficult issues about form and substance, doesn't it? If you formulate a claim in a statement of claim or in an application that on its face isn't self-evidently a public law claim against public authority for breach of for acting contrary to section 6, but you nonetheless say in a private law claim this was public authority defendant and they did act contrary to section 6 and therefore we want to revoke our convention right. Is that a section 7?
I mean, if you miss the time bar, can you still formulate your claim in common law? Taking all these same points.
Also, and nor are you shut out from taking the section 6 point as far as the court's ruling is concerned. There's nothing in the EWCA saying you can't, that objection doesn't apply in every case. It's an absolute. The outcome must not be inconsistent with convention rights.
The time bar is not, it's extendable, isn't it, in discretion?
I think it is.
Well,
It's a year.
it's prima facie.
Subsection 5b allows the court to extend if it thinks it's equitable. Yeah. So I suppose you could have a situation where you, it might make sense to do that if you've got a parallel common law claim. I don't know.
The question would then be whether you would have a right to proceed at common law, even if they couldn't persuade the court to exercise its discretion under the section.
The court couldn't simply ignore the time limit. It wouldn't be acting incompatibly with convention rights if it refused to apply convention rights when they were time-barred. Time bar is an established part of Mr. Ansberg's jurisprudence.
Yes, no. I was saying, if you were presentation period of common law claims,
Quite. No, that could happen. If you had an ordinary contract claim or claim for trespass, you could pursue it irrespective of the Human Rights Act.
But your conversion of your goods by the intelligence service, trespass to your goods by the intelligence service. You may want to take an Article 1 Protocol 1 point within it.
But this is, I think this time limit is mainly designed to deal with situations actually where there is no common law claim, probably, where you could get damages against the public authority, for example, for its misconduct under the Human Rights Act.
Yes, which would have been the case originally before the common law developed, if you simply asserted the Article 8 rights.
Yes.
Before there was a case law saying that it adjusted the law of confidence.
Yes.
I'm conscious of time, and I want to rattle through these points. The second point I wanted to deal with was the point about section 7.2, where my own friend adopted Lord Mance's point about that being effectively, the wording of that being effectively determinative of the construction of section 65.2a. I mean, our answer to that is that, with respect, that the emphasis in section 7.2, probably worth just reminding oneself of it, it's page 146, in the core volume in the appendix. It just seems to us that the emphasis is not on appropriate court or tribunal. The emphasis is on as may be determined in accordance with rules. And the point of the first half of subsection 2 is it's telling the reader that the mechanism by which you determine the appropriate court or tribunal, whatever that may mean, is by rules made under the HRA. It's a standard statutory provision identifying how jurisdiction is allocated. It's the sort of thing you see in Courts and Legal Services Act and those sorts of provisions about allocation of jurisdiction. Courts question, how do you do it? Who can make the rules? Well, you need an answer for that in the statute. You get it from subsection 2, read with section 9. And that's really what the emphasis is in the first half of subsection 2. It's not trying to define what is or is not an appropriate court or tribunal, or saying that if you designate a tribunal, that necessarily must mean court or tribunal. Third point, and this is where it gets a little complicated, and one has to go back to RIPA. Malone Friend said, looking at in section 65, 2A, if you recall, well, what does 65, 2A add to the complaint provision, to the possibility of a complaint about conduct and challengeable services? And he suggested it really doesn't add anything. Now that is, with respect, completely wrong. And if I could just give you an example, which I hope I won't be cited the West Road as being fanciful like my other examples, but cast the mind back to Harold Wilson and his obsession with the security services. Suppose a member of the security services receives some private information about a politician, not using any investigatory power that arises under REPA, but just the usual thing, a source giving the information to the security services officer. Source in the pub, rather like the source gives private information to the journalist and it ends up in the newspaper. Nothing to do with REPA, nothing to do with state powers or anything like that. But a classic example of the security services gathering information, the gathering information part of the function of the security services.
Well, I thought that is controlled by REPA, isn't that a CHIS, a covert human intelligence source?
No, that's running a covert source, I don't think it's spec. That's what's covered.
Well, there it is. I mean, maybe that's right. Let's
All
assume.
right, well, suppose
Assume it. Assume it.
Supposing the information comes with a brown envelope, there's no identified source, no role is being run, no form is being run, it just turns up in a brown envelope. And in order to malign the politician, the security service passed the information to the News of the World so that it's published to discredit the politician. That would be information gathering and disclosure in pursuance, in literal terms, of functions of the security services. But the person whose private information ends up being disclosed would want to bring a claim about an Article 8 violation if they knew the facts, without doubt. The security services in that situation is no different from the journalistic source that leaks private information about a celebrity to the newspapers and it ends up being published. There is an interference with that person's privacy. The person would say, well, this is Article 8. There's no justification here for the security services doing this sort of thing. I want to expose this and I want to challenge this as an interference with my Article 8 rights. It's an abuse of the security services powers. Now, in the learned friend's case, that would be forced into the IPT under Section 7(1)(a) if it was framed as, under Section 65(2)(a) if it was framed as a Section 7(1)(a) case. But it certainly wouldn't be a complaint. It's not a grievance that arises about any conduct of any challengeable circumstances. And the question you're left asking is, and everybody would be asking in that situation, is why on earth couldn't and should a case of that sort be tried in a court? And what's more, in a court sitting openly with the public and the media allowed to know what has happened.
Sorry, why wouldn't it be actually within 3A? There'd be proceedings on your example against one of the intelligence services.
It would, so it would be forced into the IPT.
Well, only if it's a complaint, depending on what that means.
No. 3A, if it's a Section 7(1)(a) claim about violation of the Article 8 rights by the security service,
Yes, I see.
it gets forced into the IPT.
Yeah.
But there are no
but
circumstances. All that happens is that the security service receives a brown envelope.
No, sorry. Why would it be? If charitable circumstances arises under D.
Because you have to get to subsection 8 under D in the end.
Yes, right.
And moreover, you have to get through 7 and 8. So you have to say it takes place with the authority or purported authority of anything falling within subsection 8. That is a statutory authorisation. So there's no statutory authorisation here. The circumstances are such that it would not have been appropriate for the conduct to have taken place without it, or at least without proper consideration of having been given to whether such authority would be sought. Then you go to 8 and you look at the statutory authorisation.
But the argument against you is that D is dealing with particular circumstances, but 3A is general. And how do you narrow 3A is the question, I suppose.
No, on this point, I was just giving the learned friend submission that 2A read with 3A adds nothing to D. You remember? And he said, well...
No, he says it does add to D. He says it adds a lot to it. What he says doesn't add to anything is 5A, read with 3D.
Well, I may have misunderstood that, but the example is still an important one, and a good one from the point of view of our long list of examples of cases that shouldn't be forced into the IPT. Why should that be forced into the IPT under section 718? It's a classic case for a hearing in front of an open court.
Well, if it was passed, one analysis would be that the member of the security services was simply acting on a frolic of his own, as if he got information from his wife and passed it on to someone else to malign a third person. If it was the security services who passed it on, then presumably they did so for some reason, and the issue would arise, what reason, and wasn't this a reason which might be better dealt with in secret?
Yes, but assuming that's not the case, supposing the reason is there is absolutely no justification.
Well, why won't the tribunal duly find that, if that's the case, and then they'll publish their decision?
Yes, but the litigation will not be subject to the open justice principle. The litigation will be private.
I know, but your example begs the question as to whether it's a good complaint. That's what the tribunal got to decide.
But assume it well, it does, but assume it is a good complaint.
Well, then he'll win and it'll be published.
No, but there won't be open court proceedings. There won't be an open hearing. I mean, the High Court would have a wide latitude in that case to say, look, there's a lot of the issues in this case that can be heard in public. For example, his case against the intelligence services, his complaint would be heard in private in the IPT. You would say he would be entitled to be putting his case in the High Court with the media able to report this complaint against the intelligence services. It would be a worrying thing in democracy if that wasn't the case. Would it not? One of the points that we perhaps haven't emphasised enough about REBA is that it's mentioned in the case. The background to REBA really was Article 8, and it's all very well from a learned friend saying you could formulate complaints under REBA as having some sort of Article 10 implication about your ability to communicate information if they were to do with interception of communication, so on and so forth. But the thrust of REBA, when introduced as a bill in Parliament, as a response to the Halford case, was that Halford versus the UK indicated that there were all kinds of circumstances in which investigatory powers could be used to interfere with people's privacy rights that weren't regulated under the current law. And REBA was an attempt to cover, with a complete blanket of statutory regulation, all the sorts of things that investigatory authorities might do that would interfere with your Article 8 rights by a regulatory regime, so that you would get the Article 8 issues being properly considered by the state before, within a structured regime, before your privacy was interfered with, there would have to be a proper justification. REBA is about Article 8. It is not about publishing books, and that was not what REBA was introduced for. It was introduced to deal with interferences with privacy by the state. That's why, to try and, you can always try and reformulate some grievance that might arise out of REBA by way of complaint as involving some sort of issue about the Article 10 right, but it's really not the thrust of REBA, which in a sense is one of our base concerns in this case, that we've been caught by a piece of legislation that wasn't devised by Parliament to deal with this sort of case. I think technically, again, I may have got this wrong. It's wrong to say that the jurisdiction of the tribunal in relation to complaints doesn't go any further than the statutory powers regulated under Parts 1 to 3 of REPA. Because you can see in section 65(8) at F that the last category of authorisation, which can give rise to a challenge of the circumstance, is an authorisation under the Police Act, which has nothing to do with REPA. It's an authorisation by a chief constable to allow a police officer to interfere with somebody's property. And I'll come back to that in a moment as another example of a sort of case that could come before the tribunal, which has nothing at all to do with national security implications. But the reach of REPA, at any rate under section 65 itself, and the jurisdiction of the tribunal is slightly further than just the REPA powers themselves. As far as the suggestion that it would go against the grain of REPA to read into section 65(2)A the sort of form of words that we were discussing the other day, for example, at the end of 65(2)A, and relate to the investigatory powers regulated under the Act.
I thought it was reading into 3A.
Well, in terms of general effect, you read it into 65(2)A, because then it would catch all of the categories. But in terms of a narrower reading down that would protect our position, you'd read it into 3A. Exactly. Which is part of the difficulty of the process of deciding under section 3 what the obligation is, how far it goes to read in words. Are you just reading in words that protect the human rights of this particular claimant, or are you reading in words to protect rights of other people? But reading it into 3A would certainly achieve our aims and protect our rights. But the point I was going to make is that in whichever subsections it's in, we don't agree with the suggestion by my learned friend that it goes against the grain of the Act, to use Lord Rogers' memorable phrase, precisely because of the point that I've just made, which is the grain of the Act is about protecting Article 8 rights. It's about protecting people against interferences with their privacy by state investigatory agencies. That is indisputably the grain of the Act, and it doesn't go against it to protect my client in that way, in a case that is about publication rather than use against him of investigatory powers. My learned friend referred you to the examples in two statutes of the phrase only appropriate tribunal or appropriate tribunal being used similarly to section 65(2)A, and they are in bundle 10 at tabs 97 and 98.
These are later statutes, aren't they?
Yes, these are the 2003 Extradition Act.
Is it permissible to use the provisions of later statutes to construe the earlier statute?
I'm not sure it is, but it doesn't seem to us that these are a problem for us, even if it is permissible, which is the point that I wanted to address. You'll recall that we said in our summary of our case that we thought these provisions were equally consistent with our interpretation of what court or tribunal means in any statute. Remember, we said a tribunal may be a court or a judge, but it's a specialised jurisdiction, statutory jurisdiction under the prerogative, whereas a court is a court of some sort of general jurisdiction.
I think these are being referred to as examples of uses of words, really, of what Parliament could have said if it had meant certain things.
Yes.
But it seems to us that where the word tribunal is used in these statutes, it's being used in exactly the same sense that we say tribunal has in this in section 65(2)(a) and in other statutes dealing with the jurisdiction of courts and tribunals. Because each of the two tribunals are not, in any sense, courts of general jurisdiction. They are specialist tribunals. They are statutory bodies set up within a detailed statutory regime to deal with a particular problem that Parliament is facing. So in the Extradition Act, tab 97, we accept that the tribunal is a judge. It's a particular judge who's appointed or designated as an appropriate district judge to hear extradition cases.
I think it's tab 96, actually.
I'm so sorry.
Section 195.
It is 96, I beg your pardon. If you look at sections 67 and 139, the appropriate judge, 67(1)(a), is a district judge in England and Wales, or a sheriff in Scotland, or a county court judge or resident magistrates in Northern Ireland, who is designated for the purposes of this part. So the designation takes the judge and makes the judge the specialist tribunal for the purposes of dealing with extradition cases. And there's no magic in the word judge. We must remember that in employment tribunals now, they are chaired by an employment judge. Doesn't make them any less a tribunal just because the title of the person, one of the people who forms the body, is judge. And so section 195 is the equivalent of section 65(2)(a), and we say it's doing exactly the same thing. It's making clear that the only appropriate tribunal, in our sense, a body of specialist jurisdiction, rather than a court of general jurisdiction, that can hear proceedings in the field of extradition, section 7(1)(a) proceedings, is such a designated judge, and that makes perfect sense.
Does it? I mean, I haven't got the scheme of the Act totally in mind, but you're not suggesting that you could bring proceedings in some other ordinary court, are you? Under Part 1 or Part 2 of the Act?
Well, we say exactly the same as we say in relation to 65(2)(a), which is the effect of these words is not to, in principle, exclude the jurisdiction of the ordinary courts under CPR 711, which is in general terms, but in practice, if you tried to bring your section 7(1)(a) relating to the use of extradition powers against you in the admin court, you'd be shown the door in the same way that Mr. Justice Collins described 90% of the sort of claims that might arise under REPA being shown the door in the admin court, because there was a specialist tribunal which gave an adequate remedy. And so any jurisdiction in the admin court would inevitably be declined.
At the end of the day, this doesn't amount to more than this. The word tribunal can have a broad meaning, judicial forum, or a narrow meaning, a tribunal as opposed to a court, depending upon its context.
Yes.
And when we look at the context here, it's something of a conundrum, because you can argue it either way.
You can argue it either way. And you can do exactly the same, although at first glance it's even odder under the PTA, because what happens under the PTA 2005 is that the High Court inherits the jurisdiction of SIAC to supervise the Secretary of State making control orders. If it's a non-derogating control order, the court can review it, and if it's a derogating control order, the Secretary of State has to apply to the court to get permission to make the order. But that's not the High Court sitting in its normal jurisdiction. That's the High Court applying a very detailed statutory regime in the PTA 2005 for reviewing acts of the Secretary of State. And so my learned friend's point, as I understand it, is that because the actual specialist tribunal is a court, is the High Court, therefore this is a good example for him. But it really doesn't, on our case, advance it at all, as Lord Phillips says. It depends in all of these statutes whether you give it the narrower meaning or the broader meaning. And it's a bit of a sleight of hand to say these two examples help, although I can see why he's using them, because in one case the tribunal's a judge, and in one case it's the High Court. But it doesn't answer the question, what is the meaning of tribunal generally when this form of words is used. I just wanted, if I could, to challenge my learned friend's suggestion, although I understand why he makes it, that we're sort of saying, well, on our construction of 65(2)A, going to the IPT is optional. It all makes it sound very free and easy, but I'm sure the court has our point. In practice, it's not going to be free and easy if if the substance of your claim falls within the specialist area of the tribunal concerned, of the appropriate tribunal concerned. Here, the use of investigatory powers. In the case of a claim started in the admin court or in the High Court, you'll end up in the admin court and you'll be shown the door on the basis that you should be in the specialist tribunal. And in the county court, you would undoubtedly be told that your case is an abuse of process, because there's a specialist tribunal which Parliament has given jurisdiction to. We're not saying it's an option in the sense of you have the right to pick and choose. You are subject to having to persuade the admin court that yours is a case on the fact which should be released from that restrictive procedural procedure in the tribunal, as indeed we did successfully in this case. I just wanted to say a word about C versus the police, which my learned friend referred to, which is at 1.6 tab 19. Is that right? I'm sorry, bundle 1, tab 6. There is something that we agree on, which is that this is of only slight assistance in terms of the ruling in the case. Obviously, it's just the view that the IPT took on the particular facts of the case, that it didn't have jurisdiction. But learned friend didn't take you to paragraphs 86 and 87 of the tribunal's ruling, which does indicate the underlying concern which they had in mind on the facts of C versus the police, which led them to decline jurisdiction on the basis, if you actually read the decision closely, what they say was the spying on the injury award claimant in his garden wasn't actually a police operation. It was just a collateral activity of the police in a pension situation. But they say at 86, very tellingly, the sort of thing that we're saying in this case. They say a coherent REPA scheme includes the special procedures for dealing with claims and complaints about the use of investigatory powers in performing the core functions of the public authority. The special procedures are not required for and do not fit a case like this. The application of the special procedures for adjudicating on claims and for investigating complaints would mean the applicant would be deprived for no sensible reason of the protection of ordinary procedures of an open adversarial hearing, of a reasoned decision, and of a right of appeal against or judicial review of an unfavourable decision. It's improbable that Parliament ever contemplated that these restrictions would apply in a situation in which there is no sensitive information or intelligence, and in which no national security or other public interest considerations could arise. So they're not jumping at the possibility of construing their own rules, the legality of their own rules and the Article 6 compliance of their own rules there and varying them.
They didn't say, it doesn't really matter whether we've got jurisdiction or not, the claimant can start where he likes.
No, on the facts of the case, what they did was they came up with an interpretation of what is a police operation that enabled them to say it doesn't fall within REPA at all. As I say, they didn't go down the other route of saying, well, we can make our procedures adversarial and open justice to hear this case. And remember, it was the complainant who wanted them to hear this case. and the police authority who didn't want them to hear this case. They say no public interest would be served by giving the tribunal exclusive jurisdiction over such a case. No canon of statutory interpretation requires REPA to be read in a way which would deprive the citizen of the ordinary procedures for determining his civil claim. On the contrary, we think clear wording and a good reason would be required for depriving the ordinary courts of their jurisdiction to deal with a case like this. So even the tribunal itself has difficulty with the breadth of the sort of statutory complaints that might be brought to it under REPA, and has to ask itself, why on earth is this being brought here?
So under what provision was the claimant saying it did fall within their jurisdiction?
Well, he ran it as, if you look at, I think, the early paragraphs, he ran it as an Article 8 argument. If you look at 2...
No, but he has to get into 65. How does he get into it?
Paragraphs 30 to 32.
30 to 32, really. So he's trying to do it through 3D.
Well, I think he was also running, if you look at 2, a section 71A claim. If you look at 3 and 4, I think he was one of those claimants who ran both horses and said, well, the substance of the complaint is the same, but I'm framing it as challengeable circumstances and a section 71A case.
But which of the headings in section 65?
He has to bring it within 65. Where, on the face of it, it's, Lord Clark points out, it's paragraph 30, challengeable circumstances of specified conduct, 65 3D. I mean, this was either directed surveillance or it wasn't, and if he failed on that, and therefore they have no jurisdiction, end of story. But I mean, what do you get from that?
Well, what we get from it is the tribunal is alert to the problem that its procedures, there's no apparent reason in a lot of cases that people think can be brought before it. I mean, there was a good tussle on the question of whether it was directed surveillance or not. I mean, ultimately they reached a construction of the provisions in the Act which enabled them to say we haven't got jurisdiction. But, I mean, my point is, look at the sort of cases I was going through yesterday. For example, the complaint that the key to my encrypted commercial material has been lost or has been disclosed to a commercial rival, and I've suffered loss and damage because this has happened, because the local authority has done it, or because the HMRC has done it. Surely those comments that are made in those paragraphs 86 and 87 would be made in exactly the same way in that case. In that case, it is squarely within REPA. There's no clever interpretive manoeuvre that could get you out of saying that's a 65(2)D case. But you'd be left asking yourself, why on earth does it have to be heard in the IPT? Why on earth does it have to be heard in the IPT? Makes absolutely no sense at all. It is a fairly standard confidential information, abuse of confidential information complaint in which the person says, I've suffered loss or damage as a result of my confidential information being abused or my private information being abused. I mean, we went through the example yesterday. You know, this is the official of the local authority of the HMRC who uses the key to read private letters on the computer or on the disk or something like that. That is a standard HRA Section 71A claim under Article 8, but it has absolutely nothing to do with national security or the intelligence services. And exactly the same comments apply.
That was one of the reasons perhaps why they reached the conclusion they did on the construction of the Act.
I'm sure it is on that case. I think that's what they're saying, you know, that we have to give it a stricter meaning, the idea of an investigation here, in order to say, well, we haven't got jurisdiction. This has to go to a court. It's not really the sort of thing that we need to deal with.
I mean, the trouble is that you're, as has been pointed out, you're dealing with provisions which are specifically confined. This was a claim against the police, and you had various hurdles had to be covered, but proceedings against the intelligence services are simply unconfined.
No, I understand that, but that's not the point. The point is...
well, we should confine.
Well, I'm sure you have my point. Malone and Friends construction is all or nothing. If he's right, all of these cases under C and D have to be heard in the IPT. And we say that's an absurd outcome, and it's a highly adverse outcome from the point of view of litigants who want to bring them in the courts with a full adversarial procedure. And this is a strong pointer that you should lean against his wide meaning of tribunal.
There's no support for that, one way or the other, you might say, in Lord Justice Mummery's case, is there? There's no suggestion that that both might have jurisdiction in the reasoning in C.
No, but...
On the contrary, if there is any indication, it's the other way. I'm not sure if any of the indications are sufficiently clearly the other way, but if anything, they're the other way.
Well, 87 talks in terms about no public interest in giving tribunal exclusive jurisdiction over things.
19, paragraph 19. Yeah.
Paragraph 19,
with respect, if you read the decision in that case, in each of the decision paragraphs, in relation to the particular procedural rule that was being challenged, the tribunal was at pains to say, repeatedly, and I can give you the paragraph numbers, on the basis of the not confirm, not deny policy, this is Article 6 compliant. This rule is Article 6 compliant. That was the footing upon which the decision was reached in that case. And what I'm saying is, these other complaints under C and D would not raise any issue at all of not confirm nor deny. So the reasoning in the C case doesn't really extend to cover this difficult issue of those rules being applied in my standard confidence case, where there's no national security, there's no intelligence services, there's just some local government official or HMRC official looking at your private information. The reasoning in the adjudication does not extend to not confirm, not deny cases.
Well, this Act's been in force now for 9 years, and it's plain what its primary purpose was, which was to deal with invasions of privacy. And I don't know how many complaints or claims have been made under the Act, but I imagine quite a number.
The figure is in Justice's case.
Yes.
I think is it 400 odd?
About 1,000, I think.
It was 1,000.
Yes. And is there in practice this problem of apart from this particular case, of litigants being forced off in unsuitable cases to the tribunal?
Well, I mean, the thing is, one doesn't know, I mean, we just don't have any information on that. We don't know how many complaints are brought under which provisions and what the position of the complainant is in those cases as to whether they're content to have it dealt with under the IPT procedure. But the fact is, this particular litigant is not content to have it dealt with under, and I'm just arguing general points of principle for the purposes of the construction argument. Again, that it surely can't be right that a jurisdiction of this width, which embraces all kinds of fairly routine sorts of claims, where the IPT would have to accept jurisdiction, unlike the police case, that there should be no possibility whatsoever of a court dealing with it. It seems entirely wrong with respect. The next point.
You must finish in 5 minutes.
I will finish in 5 minutes. We don't accept that the Farley decision supports Malone Friend's argument. This is not a single regime here, other than the coincidence of the date. It's two different statutory regimes. There's one regime for rules being made under the HRA, that's CPR 711, And there is another regime under REPA, which is 65(2)A, for designating the tribunal as an appropriate tribunal. And all we would say is if it is, contrary to that submission, one regime, it's not a coherent regime, because we're here in the Supreme Court yet again arguing the question of what the regime means. And it would have all been very different if there had been a hole cut in CPR 711, as it were, that said the court shall have any jurisdiction, save for cases going to the IPT after the 2nd of October. But the big problem in this case is that hole wasn't cut in the CPR. That was just left as any court has jurisdiction. We don't accept that any common law case could be reformulated as a complaint under the provisions of Section 65. It's quite impossible to reformulate a conversion or a trespass to goods case or a bias case in the divisional court as a complaint. It just doesn't fit the statutory hurdles. We don't accept that the pre-2000 this case could have been brought in the tribunal under the 1989 Act. That's simply wrong. Have a look at the schedule under the 1989 Act. It didn't have any comparable provision covering a claim of this sort. It was purely there to deal with complaints about certain types of uses of investigatory power.
Well, I mean, I don't want to spend time, but actually, I mean, the tribunal in the longer days did decide that they had jurisdiction to entertain Mr. Tomlinson's claim. I mean, that was an SIS claim.
Yes.
Who was complaining that they hadn't kept him on. It has nothing to do with their investigatory powers. I mean, we took a fairly creative, dynamic view of the jurisdiction because actually everybody implored us to, because if he couldn't come to our Star Chamber, he couldn't go anywhere else.
Because it was pre-Human Rights Act. Yeah, well, I mean, I can see that. I can see that point. Can I just deal with this point about my client's position? It was suggested at one point that he thought he was in some sort of special position because he was an employee of the organisation and therefore knew everything that the organisation knew about what or wasn't contrary to national security. We were not saying that, but what we were saying is, first, he has been given very detailed reasoning during this dialogue they've had over the book about what the national security objections are and which passages are objected to. So he's had a lot of that information. Our concern is, of course, that may not correspond exactly to the case that's put to the IPT, and it may not correspond exactly to the reasoning of the IPT. They may take a different view. And it's those two things that we won't see, the case as put to the IPT and the reasoning of the IPT. And our point is that he, as I said yesterday, he uniquely can be trusted with the information because he has accepted the obligation of confidence all along in this case. He is an unusual litigant in that sense. But he's not being vain or vainglorious in thinking he knows absolutely everything that might be said about national security. He knows a substantial amount, but there may be more that can be said. Then there were all these other questions, which I'll try and deal with, sweep up in one go, which is, well, there are all these other things he could have done to challenge the rules. It suggested he could have challenged the rules in the IPT, or he could have challenged by way of judicial review. It's an absolute nightmare from his point of view if you sit down as his lawyer and start to think about this. If he starts by challenging the rules in the admin court, he gets sent to the IPT, doesn't he, because there's a specialist tribunal. The IPT says, well, you've got to distinguish yourself from the ruling in the C case. If he distinguishes himself, if he manages to persuade them to depart from that ruling in relation to Rule 6.3, the one about consent having to be given to enable him to see the case, what will the security service say? Will they say, well, I'm sorry, we're just not going to give consent? What happens then? How is it forced on the security services to disclose the material? And even more important, you don't get the material as the IPT unless it's disclosed to you by the security services. So if we have this argument in front of the IPT and they say, well, the Rule 6.3 has to be overridden in this case, don't care that you're not consenting, we think he's entitled to know more, the security services are entitled to say, all right, well, we won't show you the documents. We just won't show you the documents. We'll make some general submissions to you, but we don't have to disclose the documents to you. What happens if he gets the wrong result in that case? Does he have to go to Strasbourg? Does he have to try and judicially review it? I mean, all this is part of the adverse consequence argument, that their construction has these massive adverse consequences for us in terms of not being able to do the very simple thing we have done, which is just go to the admin court.
You have to distinguish the Article 8 cases on notification.
Right. We don't say that Malone and Friend dealt with the Special Forces anomaly or a number of the other anomalies satisfactorily at all, and we don't accept that we're arguing for a strained interpretation of Section 65(2)A. You remember he said we should challenge the incompatibility of the statute and the rules, rather than force your lordships to a strained construction. But we just simply don't accept our construction as a strained construction at all. My Lords, I think that's really all I wanted to say. I know there is one very short point that Malone Friend would like to follow on if that's possible.
My Lords, simply in relation to the cases relied upon by the respondent in response to our Article 10 cases concerning the need for detailed reasons. The Article 8 cases relied upon are all surveillance cases. And if you look at those cases, the rationale for why no reasons can be given in those cases is because it would tip off a complainant that they had been placed under surveillance. So there's a rationale that's very specific to those kinds of cases, very different from the kind of case that we're talking about here.
We're grateful to Council for their submissions, and we shall reserve our judgment.